Let's see. All right, we hit the buttons. Let's see if it's working. YouTube likes to kick you out right when you're logging on. So looks like we're good. All right, good morning. Hope you guys are doing well. So we've got a couple things to go through today, and I want to say thank you for everybody. You guys have been super gracious. So we got some stuff fixed. The audio should be fixed. Somebody was saying when I switch between stuff, so that should be all good. We also have the chat going, so if you have questions, comments, whatever, we can highlight stuff. We can bring that up on the screen if you guys have any questions, comments, whatever. I think that'll make it a little bit easier to do the Q&A because that's been kind of tough. So anyway, today we're going to be going through three things. So the temporary restraining order got denied, and we'll talk about that. Then we also, the Olsons did a push to dismiss. We'll go through that filing. It's very, very short. And then also I got a hold of the EMD contract, so we can go through that too. And we'll kind of run through all of it. It'll be a good day. We got a lot of stuff to go through, so we're going to go through the temporary restraining order kind of fast. It is going to be a little bit of a duplicate of some of the things that we've already seen, but that's okay because the judge is basically making his determination on it, and he's going to kind of rehash everything. So if you're just catching us for the first time, it'll be great. You'll still get to understand everything that's going on. So let's hop right into it. And again, if you have any questions, comments, anything, put them in the chat, and we'll go through that kind of once we get to a pausing point. So, all right, so this is an order on motion. So basically, this is the filing from the judge. So we're at the point now where he's heard both sides. He's heard WFG's side, he's heard Eric Olson's side, and they're kind of in this process of trying to get more information, and then also the WFG was asking for a temporary restraining order, which is basically to limit his First Amendment rights and his ability to be able to speak and what he can do, trying to prevent him from continuing to recruit agents over, and the judge flat out denies that aspect of it. And we'll kind of go through why he felt that, or why he denied it. And then we'll also go through some information on the discovery. So basically, WFG wants to get additional information to figure out who all is involved. Because you remember, to this point, as far as in front of the judge, they have not figured out who actually is all involved. And so they still need to do some more discovery on that. And we'll kind of run through some of that stuff too. So again, this is going to be kind of a, this is the judge kind of rehashing everything. So he's going to let us know what WFG has said. He's going to let us know what Eric has said, kind of mend those two together, and then give his determination on why he believes that the temporary restraining order should not be pushed forward. Okay, so plaintiff, World Financial Group, brings a suit against Eric Olson and Sandra Olson, alleging a breach of their contract and misappropriated confidential business information. The complaint, originally filed in Santa Clara Superior Court, January 25th, includes 7 cases of action. So this is what WFG is alleging that the Olsons have done. So breach of contract, tortious interference, civil conspiracy, fraud, unjust enrichment, conversion, unfair competition in violation of California Business Professions Code, Section 17200. WFG is seeking injunctive relief, monetary damages, attorney fees, etc. On January 25th, Miss Olson, and her company GFI filed a complaint against WFG in this district seeking injunctive declaratory relief, attorney's fees, and costs. The next day, January 26th, Mr. Olson filed a separate complaint against WFG against the Professions Code of tortious interference, conversion, breach of contract, dealing in good faith, declaratory relief. On the 29th, WFG filed this present motion for temporary restraining order and motion for expedited discovery. Both Mr. Olson and Miss Olson filed oppositions to the temporary restraining order on January 31st, and WFG filed a reply on February 4th. So again, he's just kind of catching up with where we're at with everything. On the 5th, they filed an opposition to the motion for expedited discovery. WFG filed a reply in support of its motion for expedited discovery on the 14th. On the 7th, the court held a hearing on the temporary restraining order and the motion for expedited discovery and ordered supplemental briefings. Both parties submitted the request briefing on the 14th. Okay, so it's going to go back through background. So this is going to go over both kind of an understanding of the companies and how they work. Again, he's just kind of reiterating everything that he's heard in the different filings. So WFG is a multi-level marketing company, sells insurance products through a network of insurance agents. Top Shannon. In addition to offering insurance products to customers, agent recruit other insurance agents to work under them, known as downlines, who can recruit more agents to work under their downlines. The structure of the downline recruits selectively is commonly referred to as a hierarchy structure. Insurance agents receive an override, which is percentage of each respective hierarchy agent's commissions. In other words, the original agent is compensated for sales for their downline or any of the sales for their agents in their downline recruits. The larger and more successful an agent is, the bigger their hierarchy is, the more compensation they are entitled to receive, and the more money WFG makes from the agent's business. An agent's ability to obtain a bonus and capacity to elevate to higher tiers is through the recruiting of agents. The insurance agents directly solicit the public to become customers of WFG and their product providers. The agents can inherit customers from other agents in their hierarchy. And he's citing Buchanan on his testimony, it looks like, that they had earlier. When first signing up for WFG, agents are required to sign an agent associate membership agreement and act as independent contractors for WFG. Mr. and Mrs. Olson, on 2003, Olson entered into this contract with WFG. He signed an annual renewal on 2023. During his 20 years, Mr. Olson was successful recruiting agents to work under him and sell financial products available on the WFG platform, such as life insurance. Mr. Olson owns and operates Pinnacle Leadership Financial Agency, which is co-branded, and he operates through which he operates his downline. He's grew the company to over 20,000 agents. Olson joined WFG as an insurance agent in 2013. Oh, Miss Olson, my fault. Normally they call her Sandra. It's confusing. Where she met Mr. Olson, her now spouse. This is based off of their testimony. She would transition from selling insurance product as an agent to managing and running. In Pinnacle 2020, Olson alleges that WFG stopped recognizing the supporting spouse role as a website and promotional materials and stopped permitting the support of spouses like her to present speeches in various WFG conferences. If I remember correctly, you guys correct me in the chat, but didn't they start doing that? That was like a legal precedence that I think either the insurance or the financial world put, was that you couldn't recognize a spouse legally in some of the promotion things. Correct me if I'm wrong, but I don't think that's a WFG decision from what I understand, but I could be wrong on that. And so he's kind of talking a little bit about that. It was these changes, she explains, that made her want to play a more active role in selling and selling insurance products and creating an income source of her own. Mr. Olson decided he wanted to leave WFG for various reasons, including because WFG alleged routinely changed its compensation structure to disadvantage its agents. Prior to leaving, Olson wanted to transfer his code, commissions from his downline, to his wife, but he was allegedly blocked from doing so of a sudden change of policy enabling spousal transfer. Olson tried to sell his code. WFG does not appear to dispute that WFG changed its policy to prevent the transfer. Mr. Olson was thus left with no ability to leave WFG and receive any compensation for the value of his business. WFG says that they did that because they kind of had an idea of what he was trying to do. Now, I guess that comes into question whether that's legal to do or not. So in October 2023, Ms. Olson resigned from WFG and started a new company to sell insurance products called GFI, which is incorporated in Wyoming, registered to do business in Texas, and has an office in San Jose. Ms. Olson hired Matthew Welsh, an industry expert who left WFG over 2 years prior, Mr. Welsh, to join her. Interesting. I didn't realize he left. Is that true? I thought he's still with, I don't know. Together, Ms. Olson and Mr. Welsh developed the structure of GFI, created the curriculum, materials, presentations, and training schedules. Maybe he transferred it to his wife. Maybe that's what they mean that they left. She recruited 4 other agents, 1 who was unaffiliated with WFG, and 3 whom had left WFG over 2 years. Wow, I wonder if they've been planning this for 2 years. That's interesting. The initial team of 5 agents, including Ms. Olson, brought in other agents who in turn brought in other agents. While Ms. Olson claims that she had not knowingly solicited any agents she understood to be under contract with WFG, nor had she instructed any GFI agents to solicit WFG agents. WFG strongly disputes this. Okay, I was going to say, if that went undisputed, that'd be funny. According to WFG, Ms. Olson, with the help of Mr. Olson, used her access to WFG confidential information to determine the high-performing insurance agents that they wanted to target. When first signing up with WFG, agents are required to sign an agent membership agreement, an AMA. Both of them signed it. This talks about the non-solicitation provision that WFG agents sign. So for a period of 2 years following the termination of this agreement for any reason, agents shall not either individually or with any other assistance, employee, directly or indirectly solicit, induce, or entice any way or in any other manner persuade or attempt to persuade any individual who is current WFG agent or with whom the agent had business contact with on behalf of WFG or its affiliated or related entities to terminate or alter their relationship with WFG to join a competing organization. They say that they also broke the confidentiality provision that they should not use, disseminate, or reveal on behalf of WFG or authorized by WFG product providers confidential information, trade secrets, etc., etc. And that is supposed to carry on even after termination. The agent is supposed to return all documents, files containing confidential information, etc. Non-disparaging provisions. Basically, you're not supposed to say anything bad about the company when you're leaving. Events giving rise to the temporary restraining order. So this is why WFG asked for it. So WFG has submitted numerous declarations from individuals attesting to the events of WFG. Argues demonstrate that the Olsons' conspiracy to raid WFG's agents for GFI at a high level. They began in January of 2023. The Olsons used knowledge they acquired through WFG to determine which high-performance agents to target. Nick Bosley's testimony said that he had worked with Olson's team in Pinnacle, described how he showed up to an office on January 2nd in San Jose, was greeted with an NDA, explains that he described how horrible he thought WFG had been and how if Mr. Bosley passed away, his wife would not have gotten anything. We just recently went over the video with Cofield and kind of some of the things that they were alleging was happening with some of the WFG agents, one of the spouses that was supposedly left behind. And so he's kind of referring to that. Mr. Olson also allegedly told Bosley that WFG was stealing from its agent. Bosley explains that during this meeting, Mr. Olson had attempted to recruit Bosley to join Olson's new company, GFI, with promises of ownership and other benefits. Allegedly explained that his strategy was to recruit the leaders of WFG's teams first, then allow each leader to bring their teams over with them. That's kind of the smart way to do it if you're going to do it. WFG also submitted declarations from others who apparently were similarly approached and recruited to join WFG in this time frame. I think they mean GFI. Declaration who were similarly approached and recruited to join. Yeah, I think they meant GFI there. Saw this message in a GroupMe chat. Hierarchy discussing WFG contends are lies about WFG. They did a presentation hosted by GFI that shows the business model, hierarchy, structure, compensation arrangement that are similar to WFG's and confidential information. WFG contends that these declarations demonstrated by the Olsons' anchor leg strategy, which involved encouraging high-performance insurance agents in their hierarchy to move their books of business and downline hierarchy to their spouse who would join Olson's team. In addition to their own declarations, the Olsons submitted declarations from others who discussed the allegedly threatening nature of working at WFG. It's threatening nature of working at WFG. Okay. And the circumstances regarding GFI's inception. That was from Welsh and Hart. testimony. Legal standards. So requests for temporary restraining orders are governed by the same general standards that govern the issuance of preliminary injunction. They're going to use some code here, some former legislative things that have happened, other cases that they're citing. A preliminary injunction is an extraordinary and drastic remedy that is never awarded as a right. So a temporary restraining order, the idea of taking somebody's First Amendment rights away has a higher standard. So you can not get a temporary restraining order and still win a lawsuit. But what they're trying to say, and what I think they get into here probably, is how important it is, the standard that they have to establish. It's a much higher standard, which is kind of interesting because if you look at the political landscape that's going on with the standards that they have for taking away the First Amendment rights of a former president is a much lower standard, which is kind of interesting, but this might be some education as far as that goes. So restraining order and preliminary injunction, the party must first establish 4 factors. So all 4 of these things, it's a very, very high standard to meet before they're willing to take away somebody's First Amendment rights. Number 1, it is likely to succeed on the merits. Number 2, it is likely to suffer irreparable harm in the absence of a preliminary relief. So if the judge doesn't step in and do something, that there's going to be irreparable harm that's caused. The balance of equity tips in its favor, and an injunction is in the public's interest. So all 4 of these standards have to be met before a restraining order can actually go into place, which is a very high standard. So they talk about jurisdiction. This isn't really important. They're just figuring out who the judge is going to be, where they're actually going to host all of this. You can read through that if you want. Snap removal, if you remember, this is when they were trying to move it to a federal court, which they have not been able to do thus far. They're still kind of fighting over that. We're going to skip through that. Here's the relevant time frames again. So January 22nd, David Spalton emailed counsel of WFG to advise he represented Mr. Olson, but not Miss Olson. January 24th. So they're just kind of going through and setting up a reminder of when all of this stuff is happening. They're kind of building their time frame, which they'll use throughout the court hearing and as furtherance. Send the filings, blah, 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 blah. The parties dispute whether email services was effective. So part of the challenge of serving, Eric, if you remember, was that they initially opened up conversation via emails. And so when WFG was responding via emails, it kind of opened up that line of communication. And then Olson's team was basically saying, no, that's not a line of communication. You still have to serve us. They've been trying to serve Olson. They said that he was kind of, they call it gamesmanship or something where he was kind of playing around. They haven't been able to serve him, so they're just kind of reiterating a lot of this stuff. So they're saying that he was not served formally under California law because it was just an email, and then they tried 4 times the last time we looked at this to try to deliver, because you have to be served if you're going to have to come in and see the court or given specific information, and basically he's been dodging that. So they don't know if he's living in another state or whatever is going on, but they haven't been able to serve that. So they're saying that that is not in compliance, so they can't really accept it. Given a follow-up exchange in which the counsel prompts the plaintiff counsel to prompt him to send written acknowledgement, they're kind of just going back and forth on that. Some more case law. Here on January 25th, there was an email specifically stated, please let us know if you authorize accept WFG's compliance of moving papers on behalf of your client to avoid the need and expense of affecting personal service. So they're saying, hey, can we use email? Will you also let me know about the service? The repeated follow-up emails asking confirmation regarding service. Believe WFG's argument that understood that Spalton had agreed to that service. Under these circumstances, the court finds that communications between the parties demonstrated was not deemed effective before the Olsons removed the case to this district. Accordingly, removal was permitted under the literal reading of the section. So they're still working on that. To obtain a temporary restraining order, WFG must satisfy a 4-factor test, which we just read. It's likely to succeed on its merits. It's likely to suffer irreparable harm. Equity tips in its favor. An injunction is in the public's interest. Likelihood of success on merits. So this is coming into the judge's opinion on what WFG has provided in success or lacking in the proper information to actually be able to give a temporary restraining order. And so he's going to kind of go through each of these. So breach of contract. WFG contends that there's evidence demonstrated that Olson breached this contract. They're going to go through some case law. Fundamentally, California has materially greater interest in the demonstration of the particular issue to demonstrate ties to Georgia. WFG highlights both: one, WFG agents and defendants are registered to do business within Georgia. Their headquarters are in Georgia. Company employees working in Georgia dispute this connection. So basically, the challenge is because the lawsuit's happening in multiple different places, they're trying to bring it all kind of under one roof. And they're basically letting it all happen in California. So the other ones that were filed in Wyoming, for example, the WFG versus GFI, they are basically putting a stay on it. And a stay just means that they're holding off until the determination of California. So again, all this is just kind of the political stuff of where do we actually do this and who has jurisdiction over everything. All right, business code. WFG is likely to succeed on the merits of its breach. Contract claims turn the application of this section provides every contract by which one is restrained from engaging in a lawful profession, trade, business of any kind is to that extent void. So basically saying that you can't have a non-compete if it stops from somebody from doing their lawful profession, their trade, business of any kind. To that extent, it would void any non-compete, any non-solicitation. And they're referring to this case code. An employer context, incomplete clause, employer contract, no matter how narrowly tailored, that does not satisfy an exception in this chapter. Okay, first, the parties dispute whether Section 2.1 of the agreement should be treated as a non-solicitation. So they're kind of arguing, is it a non-solicitation or is it a non-compete provision, because they are very different. If you remember, non-solicitation means that you can't go talk to the agents or the clients of a former company, which is very different than a non-compete. A non-compete says that you can't do anything in that profession for whatever that time frame is. So it means if you had an insurance license, you can't go recruit people, you can't sell insurance under the non-compete, which is very different than the non-solicitation. Non-solicitation says just don't take the old stuff. Non-compete says you can't even do new stuff. So they're debating whether WFG's agreement is a non-solicitation or a non-compete, because the level of aggressiveness that it has is very, very different. And then they're going to talk about some case law that has some similar, so Laurel, because the former can be permitted under certain circumstances, but the latter is voidable. Olson argues that the overlapping restrictions in the agreement restrain any departing agent from competing against WFG. So Olson's saying it falls closer into a non-compete because they don't want you to do anything to compete against WFG. So the agreement at the bottom amounts to a restraint of employees' mobility, and thus void under this section of California Code 16600, where obviously WFG is going to say it's closer to a non-solicitation. All right, so here they're going to talk about Edwards, which is another court case, and kind of how it relates. They're going to talk about, here's Edward Laurel Morris, and they found in this agreement that a restraint on solicitation of customers or on disclosure of confidential information, that a non-compete agreement was upheld. So if it's a non-compete, that's okay. That's been upheld in the state of California. But if it's that type of non-compete agreement was upheld, which is more of a non-solicitation. But if it's a non-compete, it's going to be a harder thing for WFG to stand on. So the court reasoned that the agreement only significantly affected the plaintiff employees because they were not hampered from seeking employment with defendant's new employer, nor did the agreement prevent the plaintiff's employee from contracting the contracting defendant. The only option employees lost was the option of being contracted by the defendants first. The court further reasoned that the restriction presumably was sought by the plaintiffs in order to maintain a stable workforce and enable the employer to remain in business. Thus, the court found that the non-interference agreements had the apparent impact of limiting the defendant's business practices in a small way in order to promote the employer's business. It did not find that agreement to be void on its face under this section. So as long as it's a non-solicitation, it's okay. If it's a non-compete, that's not going to be okay. WFG argues that Edwards could not have diminished the holding on Laurel because the Edwards court did not address the issue of non-solicitation agreements. The issue is not raised in the Court of Appeal. Courts have considered the impact of the Edwards holding. For instance, expressly stated that it doubts the continuing viability of post-Edwards, but nevertheless evaluated that the agreement at issue using Laurel reasonableness of standards. Other courts, they talk about two other cases in here, which we'll kind of go through. Winning Brands and Gearhart. So they'll kind of reference some other things that were upheld there. So basically what they're trying to do is show to the judge how previous case law has been upheld or has been pushed down to show him how it's kind of already been applied so that he'll make a recommendation obviously in their favor. So each of them is throwing case law at him, showing examples of similar things that have happened before, so that way he has a better understanding of kind of how to move forward. So faced with the sizable body of case law in its districts and others, the court finds that Edwards at a minimum cast doubt on Laurel. So one is saying, let's look at this standard. The other one's saying, look at this standard. And then they're kind of competing on the two. Well, this one said this and this one said that. So this isn't going to work. And obviously they're both finding cases that are beneficial to them. And this, it said a non-solicitation provision would actually have a negative impact on their business. So it wasn't held up. Yeah, ask your question and I'll pull it up in a minute. Finding demonstrated the profitability of prevailing through merits in its breach of contract. Claim where there was contractual provision at issue is restricted. The ability to practice their sales profession in the ML industry, which relied on agents' recruitment of new agents. Both Olsons have alleged that agreement's prohibition on solicitation would impact their chosen post-WFG career. So again, non-solicitation would say they can't recruit WFG agents or take their clients. Non-compete would say they can't do anything in the industry. So obviously the Olsons are trying to make it seem as close to a non-compete as possible. WFG is trying to get it to move as close to being as a non-solicitation as possible. And they're just kind of arguing case law through here. Even if Laurel was a good law, the parties disagree on how to characterize the relationship. So they're bringing into, even if that's okay and Laurel is good law, well, we're still disagreeing on the relationship between WFG and Olson. Are they two businesses kind of competing with each other? Is one seen as an employee and the other the employer? Because that's going to impact how this looks. And they they talk about this one, whatever that is. And so they're kind of bringing that in to explain, well, this is more of a employer-employee contract, which changes the law as far as that goes. So focused on policy considerations specific to employment, mobility, and competition, and ready the case exclusively from an employment context. So it could be different if they see Olson as an employee versus as a business partner, so they got to kind of figure all that out, and they're arguing that obviously to their sides. The court agrees with the defendants that the relationship with WFG is more appropriately characterized as falling under the employment context as opposed to one of the business to business, which WFG argues that the agent language stating in WFG will provide agent with a platform through which the agent can, if the agent chooses to build the agent's business, and the parties shall operate their respective businesses separately and independently of each other throughout the duration of this agreement, demonstrates a business to business relationship. However, the agreements at issue are between WFG and Olson. So WFG and Olson, the individual. Other aspects of the agreement support characterization of the relationship as falling within an employment context For instance, the agreement states that it is not a franchise agreement. Additionally, all agents in WFG, in Olson's hierarchy, are paid directly by WFG. So the judge is making the case that it sounds more like Eric is in more of an employee position, even though they're independent contractors. They're determining the role here, right? And so the judge is citing more with Olson that he's more of an employee on that side than he is a business partner. And the reason why this is important is because one has more power over the other, kind of, if you will. So in addition, WFG has not cited, and this court is not aware of any cases where individual was treated as a business. So since the lawsuit is against Olson directly, they're saying that that obviously is company, business, and individual, not business and business, because it's against Eric, it's not against the company. So they're kind of using that site code or that code in the section 16600 to say that he's more of an employee. Okay, the court will not treat the agreement as one between as two businesses, and thus will evaluate whether the provisions are void under the Edwards framework contract. The non-solicitation provision, for the reasons explained above, the court finds that WFG has not demonstrated a likelihood of prevailing on the merits of its breach of contract claims grounded in the non-solicitation provision. All right. Confidentiality provision. Mr. Olson argues that the confidentiality provision is void under this section as well. Unreasonably restrictive. Again, if it falls into a non-compete, it's too restrictive, including because the provision only carves out information that WFG has made public and makes no effort to tailor the scope of the clause to information that holds any competitive value to WFG. So he's saying that the non-solicitation is too broad. It needs to be more narrow. And WFG responds to the provision containing limits, principles that make it valid, enforceable, and consistent with confidential provisions other courts have upheld. So WFG is saying, well, pretty much all the other companies have a similar non-compete, so it should be upheld. Use and dissemination of any confidential information. So now they're kind of arguing over that. May disclosed of any agent. So what is actual confidential information? If it becomes generally available to the public other than as a result of disclosure by an agent, any assistant or any member of WFG's network of confidentially affiliated agents, the court finds the confidential provision, while broad, is not so broad to be void under this section. So unlikely the confidentiality provision in Brown would define confidential information as any information that is usable and relates to the entire securities industry. The confidential provision here is not tailored to personally identifiable information or confidential information created by or on behalf of or belonging to WFG. So they're kind of in confliction here. And the court finds that the confidentiality provision, while broad, is not too broad to be void under that section. So the court does agree with WFG on this particular point. But kind of what he's saying is, or what he's still trying to figure out, is that not the entire securities industry, right? That can't be void as confidential information. So they've got to have it be narrowed down into what actually belongs to WFG. The agreement's exceptions for information WFG has disclosed would seemingly exclude information that Olson's argue is already public. So that kind of became the question we had earlier. So if WFG has released information, or people have released information to the public, take, for example, the structure of WFG, since that's already public, PHP's taken it, PFA, HGI, like a bunch of other companies have already taken that similar platform. So it's already public information. So can you still say that it's confidential information if it's kind of already public information? So including information regarding hierarchy lists that have been published online. So if WFG makes an announcement of people doing well in the company, now it's published online, is that still going to be confidential information? Okay, turning to whether WFG has demonstrated its likelihood of success on merits with respect to its claim of breach of confidentiality provision, the court finds that at this stage it has not. So they're saying that WFG has not presented enough evidence to show that GFI and Eric have actually taken confidential information. WFG argues that defendant revealed WFC's compensation structure on a public Zoom meeting. So basically they supposedly did a Zoom meeting with a bunch of WFG agents, and they were explaining the difference in the compensation in order to recruit agents over to GFI. The presentation does not appear to have been made by the Olsons. So the judge is saying, well, the Olsons, you're suing the Olsons, and the Olsons did not do that Zoom call. So with the presented evidence, it's raising doubt too as whether the information presented would fall under the scope of confidentiality. So he's not saying that the Zoom call didn't happen, but does it actually fall under the confidentiality provision? And they're saying that the Zoom presentation was made by a former agent, not the Olsons. So the information regarding hierarchy and business model made public by WFG. Mr. Olson stating that Mr. Olson did not create or provide instruction regarding. So they're trying to separate Eric from the Zoom call that happened. The Zoom was not directed at WFG agents. I never mentioned WFG agents during the presentation, and the Zoom was public. So Welsh is saying that nobody on that call was directed to WFG agents, so that would be interesting to find out if they could get the information who was actually on that Zoom. I don't think Zoom saves that information, but if they could get that, would be interesting. He said it was just open to the public, so anybody could show up on there. So if anybody was pitched to be on that call, that would be interesting, because I think Day was on that call, right? Rob Day. So if he was on that call and he was solicited to be on that call, well, then obviously there's WFG agents that were directed to be there. It wasn't just, I mean, it could have been open to the public too. That kind of is an interesting question. So success of prevailing on merits of its breach of contract claims grounded on the confidentiality provision. So the judge is saying that WFG is not given the proper amount of information necessary to move forward on that particular one as far as relating to the temporary restraining order. So remember, we're looking at different things here. There's the actual court, so there could be enough information there for WFG to win or to continue litigating these particular points. But as of right now, it's not a high enough standard to limit his freedom of speech with the temporary restraining order. Okay? So the non-disparagement provision, finally the non-disparagement provision prohibits disparaging WFG agents, shall not do anything that damages the business, good name, or reputation of WFG. WFG argues that the Olsons have spread false information, disparaging rumors around WFG in the intent of causing and the actual result of causing detrimental reliance on those statements. To demonstrate the breach of contract here, WFG chiefly describes how the Olsons have spread false rumors, policies regarding transfer of codes from the deceased to the surviving spouses. Again, the Cofield video that we just did was part of that, but only one declaration appears to discuss Mr. Olson's statement. So the challenge that they're finding here is that since Eric didn't do these specific things, why is Eric getting a temporary restraining order? So in this particular example, and I'm just making this up, so don't take this as what's happening, but let's say Welsh says some stuff and Cofield says some stuff and somebody else says some stuff. The judge is asking, why do we need to limit Olson's freedom of speech if other people are doing it? So they're not finding enough information here to limit Olson's First Amendment rights. And so they're comparing Bosley's testimony, recounting the conversation with Olson directly with Day. Both of these testimonies kind of counteract with what Olson's saying, in that he made specific things as far as scare tactics that GFI used to try to get other people over. And they're kind of referring to the statements made by Cofield here. The Olsons have submitted declarations of their own regarding these statements. So Olson here says, discussing the WFG canceling its heritage program and transferring the transfer over to spouses, stating that neither his wife have been part of any solicitation efforts. So Olson is saying he hasn't solicited anybody from WFG, or actually this is Cofield, my apologies. Cofield says that neither him nor his wife have been a part of any solicitation effort on behalf of GFI, and Eric Olson has never asked us to join GFI. So Cofield is kind of stepping in front of that bullet here a little bit and saying that I may have done it, but we're not doing it on behalf of GFI. Like, GFI never came to me and asked me to do this, which is kind of an interesting point to take. But he's like, well, I'm independent contractor. I can do and say what I want. So GFI isn't asking me to do this. I'm just going out and recruiting agents on behalf of me and my spouse, but I'm not doing it on behalf of GFI. So does that really count? Can you get away with it? I don't know. So anyway, the court finds that the evidence is insufficient at this stage to establish a likelihood that WFG will prevail on the merits of its breach of contract grounds on the non-disparagement provision. All right, tortious interference contract. So in order to state a claim of tortious interference with a contract, the plaintiff must plead a valid contract between, so they must have a valid contract in place, the defendant's knowledge of this contract, and the defendant's intentional acts designed to induce a breach or disruption of contractual relationship, and the actual breach or disruption of contractual relationship resulting in damage. So all of those parameters have to be met before that can be found to be true or not. Okay, because the court finds that WFG has not established a likelihood of success on the merits of its breach of contract claim, WFG has not established the Fourth Amendment element of this tortious interference claim, an actual breach of an agreement. According to WFG has not established its likelihood to succeed on the merits of tortious interference claim. They go on to talk about the civil conspiracy. Given the competing evidence, WFG's civil conspiracy claim derived its breach of contract claim. The court cannot find WFG established its likelihood to succeed on the merits of the civil conspiracy. Unfair business practices. Because the court finds WFG not to have established the likelihood of success on the merits of the breach of contract claim, WFG similarly has not established that it is likely to succeed on the merits of derivative UCL claim. Irreparable harm, balance of equities. The court need not address the remaining factors because it has failed to show the likelihood of success on its merits. So this doesn't mean that WFG doesn't have these points to make. What they're saying is the standard is not high enough right now to then say we're going to take away Eric's First Amendment rights. Next thing they're going to talk about is motion for discovery, which we'll get to here in just a second. But basically, part of the reason why WFG is lacking in the information that they need to get a temporary restraining order is because they haven't been able to do discovery yet. Meaning, you and I know, everybody watching this knows that there are people who have been recruited from WFG to GFI. We know that, right? We know that there's information out there on social media showing that this has happened. Everybody can see that this stuff has happened, but the court needs a higher standard than that. And so if they're not able to meet that standard, they're not going to get a temporary restraining order. It doesn't mean the case isn't still moving forward. It is. They just haven't set that standard high enough for a temporary restraining order. Okay. They also filed a motion for expedited discovery. So expedited discovery is them requesting to start doing subpoenas. And a subpoena basically means that the judge is allowing them to get the information they need, whether they need someone to speak out of things that happen that doesn't want to. The subpoena basically forces them to do that. They can also subpoena phone records. They can subpoena other information that they need to get that they don't currently have, which could lead to a temporary restraining order in the future. But as of right now, they have not met that standard. Okay, so WFG argues that good cause exists for multiple reasons, including because defendants are active misuse of WFG confidential and proprietary information, is disparaging to WFG, inducement of WFG insurance agents and customers. So yeah, even WFG is saying that GFI is taking agents and customers. So that's interesting to note there as well, because that one is actually against insurance laws. So defendants are using the encrypted and self-destroying messaging app Signal to erase related conversations. WFG claims defendants are engaged in unfair business practices. These types of claims that warrant expedited discovery. WFG cannot identify all the defendants and needs discovery to identify them. So the Olsons argue that they didn't file the expedited discovery in the right way, that they're lacking evidence, because obviously Eric's not going to want to turn over his text messages, right, and his phone calls and his meetings and where he was and all of that kind of stuff. So he doesn't want them to get discovery, and of course WFG wants information so that they can move forward and figure out who all's involved. WFG's authority is distinct because it involves claims not alleged here. Allowing expedited discovery would put the cart before the horse. So they're saying, which is kind of a fun game to play, right? Because it's like, well, you don't have any evidence, so why would we open up discovery? Because you don't have any evidence, or you don't have enough evidence yet, so why should we give you more? And then WFG is like, well, we don't have enough evidence because you need to give it to us. We need to get it from you and from people who aren't willing to give it to us. So Olson's new business giving access to the court finds a good cause to permit limited expedited discovery. So this is evidence that the case is still moving over because the judge is going to let them start doing discovery. It means they can start digging into what's going on, getting phone records, testimonies, whatever they need. The court is going to allow them to do that. WFG has provided evidence showing that defendants have used encrypted messages, that events are happening right now. Additionally, the Olson stated prejudice is not persuasive because presumably WFG will have access to the identities of WFG agents during the normal course of discovery. So in discovery, they're going to figure out who all is involved. Nevertheless, court finds that this time it cannot properly evaluate whether the requests are narrowly tailored. According to the court, it defers the ruling on extended expedited discovery and orders WFG to file a proposed identifying the specific document requests and who they want to interrogate and 30-party witness subpoenas it seeks within 3 days of this order. And we do have that, so we'll go through that next. So basically the court is saying it's too broad. Like you wouldn't show up to Eric's house and go through his underwear drawer. Like that's just too broad. So the judge is asking, what exactly do you need to see? Let's narrow this down so that we can get specifically on what we need. So now it's kind of up to WFG to say, okay, this is who we want to talk to. This is the information that we need. This is how we're going to get it. And they're going to submit that to the judge, which we have. We just don't have time to get into today. So it's still moving forward. The ball's now in WFG's court to start gathering information. Who can we talk to? We need to start getting more people on our side, figure out what actually happened, start subpoenaing people to come in and give their testimony about this stuff, start getting phone records, whatever it is that they want to kind of move forward. So for the foregoing reasons, WFG motion for temporary restraining order is denied. So that is not going to happen. WFG's motion for expedited discovery is deferred, and it's deferred because they need to tell the judge exactly who and what information that they need before the judge is going to actually move forward with that. So, all right. Whew, man. All right, let's get into some questions. You guys had some stuff. And then I do have the EMD contract as well. No relation. Let's see. Oh, you can't see all of that. No relation between the two. GFI was started by agents who left WFG in the same way that WMA, which later became WFG, was started by agents who left AL. Yeah, that's kind of a good point, and this was kind of what I was saying before. Sorry, Jiang, that kind of got cut off there, but it's kind of a good point. That's kind of become almost tradition in the industry that you get to a certain point and then you go off and you start your own thing. So that's kind of a good point there. Let's see, their startup, it takes time, I'm guessing. I got a meeting with GFI this afternoon. I'm looking to either join GFI or Experior. Cool. I don't know who Eric is. All right, cool. If you don't know, IMO, structured business. All right, awesome. So let's get into the dismissal date. So the next update, basically the next step that Eric and Sandra are doing is they want to try to dismiss the whole thing, because we're kind of in a race for time here, if you can imagine. So WFG doesn't have enough information. They need to do discovery. So one of the tactics is, well, if we can get this thing dismissed, then they don't have time to do discovery, so they're trying to do that. So basically, Eric and Sandra filed that they want to move to dismiss this. So coming up, I believe on April 4th, they are going to be doing they're going to be trying to dismiss. So on the 4th at 9 a.m., soon thereafter, there may be a hearing by the judge. This is the same judge that's on the case now, to see if they can dismiss it. The motion is based upon this notice accompanying the memorandum as points of authorities. Eric's memorandums as well. The file records this action upon further evidence and arguing that the court may receive at or before the hearing. So they basically want to try to end this thing before WFG can really get into any type of discovery. So April 4th is really going to be our next date that we're watching out for, because they're going to start talking about some of the things we see if we get this dismissed. So it could be done as soon as April 4th. If they decide to dismiss it, if there's not enough information, we'll see what WFG is actually able to get as far as evidence in being able to get their discovery. So we'll kind of see how that goes, and kind of what happens from there. And then I think the court date is actually set for May. So we'll see how that goes. I'm trying to see if we can watch it live. I don't know if they'll let us. I don't think you're supposed to record that stuff, but if we could watch it live, that would be kind of cool to see what happens there. So let's see. What are the key differences between GFI? And that's probably a conversation for another day, but it seems like their structures can be fairly similar. I think the hardest part with any of these companies is you got to kind of look at leadership. For me, I don't know. I think leadership makes a big difference. A lot of people like Eric. Eric is he's good at leading people. So there's some good leadership over there. I think WFG has some great leadership. I think the comp is about the same. When you look at it, do you want a little bit more up front? Do you want a little bit on the back? I don't know. They keep touting all this stuff that's supposed to be in the EMD contract. But we're going to read that right now and see if the EMD contract is actually up to what they said it is. So basically everything that's been happening thus far is because Eric's saying that they've taken away some stuff, and so he built GFI on the premise of having more ownership and having stock options and all these things that he's been saying to different agents is what he's supposed to be getting. And so now we got a chance to see into the GFI contract. You can go watch that video as well. And I don't see anything as far as ownership goes in there that's unique for their firm than versus any others. And then now we're going to look into the EMD contract. The EMD contract is supposed to, I haven't read through all of it, so we're going to kind of do it together. It's fairly short. But that's supposed to have all of this ownership that Eric's been talking about. So the whole separation from WFG to make GFI was because he wanted more ownership, or at least that's what he's saying. So what we're trying to determine is Eric moving because he wants to become a billionaire, or is he moving because he wants to provide a better platform for people? And that's kind of what's up for debate right now. And however you feel about that is how you feel about that. But let's look at the EMD contract. Somebody sent this over to me, so I'm super grateful for them. I don't want to mention who it was, but let's kind of read this together, and I would love to hear your guys' comments on it. Let me know if this is a deal breaker for you. So whoever was asking about GFI or WFG, here's supposedly the contract. Somebody sent this to me, so it wasn't from Eric or something. So who knows, maybe it could have changed by the time they launched it, but this is what they sent me. So this agreement is made by between GFI and its sub-agencies, referred to as Executive Marketing Director, where you are a member of GFI's independent sales force and have previously entered into independent contractor agreement, which was kind of funny because when we read GFI's contract, they keep talking about ownership, but GFI's contract, I think, is even just as strict, if not more strict, than WFG's, in that they own the customer, but what they classify as a customer is somebody who's even been approached. So if you've talked to, let's say you talk to your mom, right? She's not interested in buying life insurance from you right now. And then you leave GFI and you go to another company. They're saying for 2 years, you're not allowed to talk to that person and make them a client or recruit after you've just spoken to them. And I don't know how they're going to track that. Maybe if you put that information into one of their lead systems that's supposed to track what's going on there. And then they become a client within 2 years outside of that. So it's interesting that on one side, Eric says, okay, well, this non-solicitation is too strict, but then his is just as strict, if not more strict. So that's in the independent contractor agreement, which we kind of read earlier, if you want to go through that. But whereas GFI has considered you to have earned, let me get my pen out, earned a designation of executive marketing director. So once you hit EMD, you start getting special privileges. The challenge with EMD is that it's twice as high as the standard of WFGs. So normally you have to have like 10 licensed agents, is I believe what PHP does as well. About 10 licensed agents hit a certain production level. So we're not talking a massive agency, right? Now, executive marketing director, they don't have a position in between. So that's 20 licensed agents and double the production. So once you receive that, you receive the responsibilities, benefits, and duties of the position of executive marketing director in GFI. And now, therefore, in consideration of the vested benefits, mutual promises, and covenants in this agreement, in attending to legally bound hereby, you and GFI mutually agree to the following. All right. Scope of this agreement. This agreement addresses the responsibilities, benefits, and duties of executive marketing director sales position designation, unless the provision of agents agreement expressly provide otherwise. The terms and conditions of your ICA remain in force. So this doesn't replace the ICA. It's incongruent to, you've just hit another standard. So this agreement governs all of the benefits, duties, responsibilities, and privileges related to the position of executive marketing director in GFI in exchange for assuming the duties of executive marketing director described in the following section of this agreement: vested ownership, terms, and conditions. The GFI agency guideline published through GFI contains performance standards, commission rates, and other matters affecting your compensation as published by GFI from time to time. The benefits accorded executive marketing director will be yours. Executive marketing director agreement duties. So you have advanced to executive marketing director position because you have demonstrated an ability to recruit, train, and motivate others, and ability to market and sell market and sell products and services. The executive marketing director title means that you are a leader in GFI, and its other members look at you to set an example for GFI. GFI expects you to conduct yourself as a role model and as a benchmark by which others of your downline associates and agents will measure themselves. You must be positive, encouraging, motivating leader for all of your downline associates and agents while also maintaining a minimum persistency ratio of 75%. That's pretty high. I don't know, any of you guys agents on there? I don't know what your persistency ratio is. Is it over 75%? I know it's supposed to be. Mine's usually in the high 80s, low 90s. But that's tough when you're building a team. To have a team that's staying in 75% when you're bringing on new agents, that's a high standard. That's a good thing for the industry. Hire for both you and your base shop downline. Thus, in addition to your normal duties and responsibility as an agent and or associate, executive marketing directors must accept responsibility for and form a mentoring relationship with your downline associates and agents, and effectively assist them with monitor their trainings, local meetings, recruiting, and compliance with all license rules and procedures, because you are accorded the ability to receive override commissions on the sales of the products and services by your downline hierarchy, and you have accepted responsibility of overseeing their activities. You are responsible for the debt balance of any downline associates and downline agents referred to in your ICA. So pretty standard. If you have any debt balance, if you recruit somebody and they have a big balance that they bring over, they write a bunch of bad business, it charges back, that becomes your responsibility. I wonder how much they uphold this. So if you're an EMD and you hit all the other guidelines, but your persistency gets to 70% for a period of time, I wonder if you lose that. Vested benefits and commissions. If applicable, executive marketing director who are dedicated members of GFI are vested in commissions resulting from the sales of the products and services, as well as other opportunities and benefits published in GFI's vested ownership terms and conditions. I wonder if we have that. Do we have the vested ownership terms and conditions? A person who is vested in commissions can earn commissions on applicable applications of products and services submitted during the term of his agreement by that person or their downline agents, even if this agreement is later terminated. The override commission rate for executive marketing directors shall be published from time to time by GFI. In addition to divesting provisions in your ICA, you will be divested if you violate any provisions of this agreement, including aforementioned guidelines, which are incorporated herein by reference. Furthermore, since GFI has opposed to product provider is unlimited responsibility for payment of commissions to you, notwithstanding any provision of this agreement or other agreements between you and GFI are contrary, the vesting provisions of this agreement may change in the event GFI's vesting and compensation schedules with the product providers are changed. Okay, educational requirements. As an executive marketing director, you are required to train, supervise, and create an active, motivating environment, community, or your hierarchy of associates. You shall supply agents and associates in your downline hierarchy with relevant guidelines, bulletins, memoranda, policies, procedures, etc., furnished by GFI. So what does that mean? Because here's where it gets so confusing with ownership, right? Okay, so this is saying that you must create an active, motivating environment or community in your hierarchy. You need to supply your agents and your downline. So can you not then sail off into the sunset and override your commissions? Because if you're not creating that environment, can somebody else create that environment? I don't quite understand how that's supposed to hold up. If you want to get out of the field and just write your book of business. I don't quite understand how that plays into it. It just seems like an interesting clause I would want more information on. Executive marketing director designation. Executive marketing directors may, assuming requirements are met for promotions are met, qualify for designations of senior executive level and other designations established by GFI. Thus, an individual could simultaneously be designated as a representative, associate, senior associate, marketing director, and executive marketing director. Requirements for these designations are and shall be published and maintained current with GFI. However, the current married spouses cannot both have designations that's standard. So you can't both be an EMD simultaneously, nor can your spouse be coded simultaneously in separate hierarchies. So basically you can't do the, what do they call it? The, oh my gosh, I lost it. So basically what they're doing when you have, the anchor leg strategy. You're not allowed to do the anchor leg strategy in GFI, only Eric can do it. So you can't be coded while simultaneously having your spouse coded in two different hierarchies. So you have to choose one hierarchy to be in. Furthermore, any agent or downline or associate may not be transferred within or to other hierarchies unless they are in good standing at the time of the request and have no recruiting or production activity of any kind for a period of 24 months, during which GFI shall monitor their activity to ensure compliance before completing the transfer request. As an executive marketing director, you agree to uphold follow these standards. Failure to uphold these standards or publish GFI guidelines is breach of this agent agreement and can result in its termination. So if you recruit somebody from somebody else's hierarchy, that's a big no-no. You're not allowed to do that, which is kind of funny because I think that's why all of this stuff is happening, right? So they want you to wait for 24 months. So basically they want you to sit out. So let's say I was being prospected by GFI and I'm in one hierarchy and I want to move to another hierarchy. Basically what they want to see is that for a period of 24 months, I don't have any sales, I don't have any recruits, I don't have any new business for those 24 months before I can move over. So basically what they're trying to prevent is exactly what these guys have been doing is recruiting people from inside of their own agency. Kind of comical. Okay. Individuals who attain EMD designation continue to be independent contractors regardless of any state, license, or form, and are in no way employees of GFI. Weren't we just having this argument? Oh my gosh, we just read this in the contract. So Eric is saying that he's an employee, while in his contract for GFI, he's saying that they are in no way employees. So like he keeps talking out of both sides. So in the WFG versus GFI case, he's saying, well, I'm just an employee. You can't hold me to high standards of being a business person. But then here he's saying literally the opposite, that everybody in GFI is not an employee, just like WFG says, or I'm sure PHP and these other guys say. Anyway, marketing directors like yourself conduct and control your own business activities, work hours, selection of customers, office locations, sales methods, and other day-to-day business operations, right? Because you're an independent contractor. Just like if you're a real estate agent, you choose where you work and what you want to do, your business activities, who you work with, your office location, your sales, everything else. So that's pretty standard. Termination from time to time. And at the choosing of GFI and the company board of directors, this agreement may be altered or terminated by written notice published to the company at large in order to further the best interests of GFI and its field leaders. Okay. Governing law, and this is the last provision here. You and GFI agree that this agreement will be governed by the laws of the state of Wyoming, so whatever laws are applicable in Wyoming. If Wyoming conflict or choice of law rules would choose a law of another state, each party waives such rules and agrees that the substantive law of the state of Wyoming shall nevertheless be governed. Interesting. The parties agree that the state and federal courts of Washington shall have exclusive jurisdiction of any litigation between the parties, and you expressly submit to the jurisdiction and venue of federal and state courts of Wyoming within respect of such litigation. Oh my gosh. So if you remember from the last document, Eric is basically saying that he can get away with what he's doing because he's in California, and California has different rules around non-competes and non-solicitation. So what they're saying here is that any lawsuits like what he's going through right now with WFG would need to take place in Wyoming. So somebody tell me, I don't know if you know in the chat if anybody does law in Wyoming, but I'm assuming it's way more strict. And so even if you live in California and you break the rules like Eric is doing right now, he's saying you can't use the same provisions that he's using in his lawsuit. If you do to GFI what he did to WFG, then you have to uphold the standards of Wyoming, not California, which sounds like it's more lenient. So anyway, another double standard in that contract, and that's all that's in it. So I don't see a whole lot about other information as far as ownership. I don't see any stock options here. There was another document that was referenced that, vested ownership terms and conditions. Maybe this is a document that we don't have yet. I don't know. Maybe that's where the actual vesting is, question mark. But as of right now, I don't really see it in this particular document. So there must be more documents that are still out there. So if anybody has that document, the vested ownership terms and conditions, I thought we were going to find that in here, but I don't think it's in here. So I still haven't seen anything as far as a ton of ownership or stock options or all this stuff that all of this supposedly happened because of. I just don't see it in this document or in the ICA that was previously produced. So anyway, that's where it is. Let me know what you guys think about it. I don't know. Interesting. So let's do some comments. Let's see. You guys got anything good? You guys just talking about coming in, blah, 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 blah. Any other questions you guys got? So on Wednesday, I have the documents for what WFG is asking as far as discovery. So the people that they want to subpoena, what information they want to get, who they're going to next to start working on building their case. All of that's in there as well. Will you do WFG's Heritage Unveil? I'll do my best. I don't know if I'm going to get a copy of it or not. But yeah, any information I have on either side, if you guys have anything, I'll go through it if I can. Yeah, absolutely. That's why we're here, right? We want to figure out what the truth actually is. So I appreciate you guys, and that's pretty much all we have today. The only thing that I think is kind of interesting is we have a higher standard of right and wrong for Eric Olson than we do for a former president. I think that's kind of funny. So they got the temporary restraining order. It's easier to get one on a former president than it is to get one on Eric Olson. So I think that's interesting. I do in-person poker, by the way, which trust computer. I have no idea what that is. So anyway, I appreciate you guys. Hope you have a great rest of your day. I'll catch you guys later. Bye.